Hello and welcome to the Relocation 101 Module 4. My name is Paula Hyman from the Ohio LTAP office, and I'm going to be your technical support today. Just a couple of housekeeping items, as same as last time. If you have questions throughout the presentation, please put those into the questions pod, and our presenter will address your questions periodically throughout the presentation. There are items available to download in the handout section. I emailed those after the last webinar, but if you for some reason do not have those or are unable to download those, please put your name in the questions pod and I will email those to you directly. Thank you in advance for your participation, and I'm going to pass things over to Miss Patty Moorman, Relocation Unit Manager with ODOT Central Office Real Estate. Patty?
Well, good morning and welcome back to Relocation 101. Today is Module 4. Module 4 involves computing payments for 90-day owners, price differential payments, including carve-outs, mortgage interest differential payments, and incidental expenses. There's a lot of material to cover today, so I'm going to be doing a lot of talking. We do have 2 knowledge checks, and then there also will be the quiz at the end. I also want to reiterate that if you are taking this course for credit towards pre-qualification, you are required to take the quiz and you are required to attend the sessions and take the knowledge checks. I do get a report that tells me how long you're logged on and if you've participated in the knowledge checks. So I just want to encourage you and remind you, if you're taking this course for credit, then you do need to be participating fully. This Relocation 101 does have 7 modules. We are on Module 4, so when we get done today, you are going to be more than halfway through. So with that, I'm going to just move on because we have a lot of material to cover, and you'll find that some of the things today are kind of overlapping and almost like refreshers of Module 3. Okay, the replacement housing payments of 90-day owner occupants. So in this module, we're going to discuss how to calculate the various replacement housing payments available to the 90-day owner occupants. Now in Module 3, we talked about items of comparability and the DS&S standards. Now we also discussed who is eligible for relocation housing payments and the different occupancy classes. Now we're going to discuss how to search for the comps and how to calculate both the offer and the final RHP. We will also discuss the 3 main components that make up an RHP payment. So our learning outcomes for this module: searching for and selecting comparable properties, computing the replacement housing price differential offers and payments, the impact of a carve-out on an uneconomic remnant on a price differential calculation, explain the goal of a buy-down process and the increased interest payments, determine the reimbursable incidental closing costs. So first of all, let's talk more about comparable housing and some of the basic replacement housing procedures. So the maximum replacement housing payment for an owner or a tenant is based on the cost of a comparable replacement. Now we talked about comparability in Module 3, and the criteria is further refined in sections 6604.07 through 22 of our manual. There are 15 items of comparability that you need to consider when selecting your comps. And as you remember, the required 90-day notice, which is also the offer letter, cannot be issued to a person displaced from a dwelling until a comparable replacement dwelling is made available to them. So how do we define a comp as being made available to the displacee? So a comparable replacement dwelling will be considered to have been made available to the person if, number one, the person is informed of its location. The offer letter that you will give contains the address of the prime comparable dwelling. Number two, the person has sufficient time to negotiate and enter into a purchase agreement or lease of the property. Well, the comparable must be available to the displacee at the time of the offer. As you recall, in the Module 3, we talked about the responsibility of the relocation agent to check with the realtor, or if it's for sale by owner, with the homeowner or the landlord, to make sure that house is still available on the day you make your offer. If it's got a offer, even if it's a contingent offer, if it's a lease, and it is not available, they have to be able to walk in and purchase or lease that property for it to be available, and you have to check the day you make the offer. Number three, subject to reasonable safeguards, the person is ensured of receiving the relocation assistance and the acquisition payment to which the person is entitled in sufficient time to complete the purchase or the lease of the property. And that is why at ODOT, all claims have to be processed in a very quick manner if it's an RHP or a down payment or for a tenant. So they have the money available to purchase or lease that replacement home. And usually for an owner, you're coordinating that with the realtor through the purchase agreement that the owner signs, and saying it's contingent upon money being received from ODOT, kind of as a, just a kind of a protection for the owner. So the factors that define a reasonable search are the real estate market, the search area, the uniqueness of the displacement residence, and or the timing of the project. Now, it is important that a search for comparable replacement housing be efficient and exhaustive, and you may need to know that phrase for later. This is especially true with projects that have aggressive right-of-way clear dates. The search must be well documented. The documentation need not be lengthy, but it has to be specific and it has to be complete. The documentation should include the property addresses, the number of rooms and bedrooms, the list or rental prices, contact information, and the reason the property was or was not used as a comparable. You're going to keep the documentation even on the ones you choose not to use. That supports your search. So let's talk a little more about the components of a reasonable market search. So if a market has a very limited number of houses for sale in the search area, or the market is very active, resulting in the home selling very quickly after they are listed, which is what we're seeing out there right now, the relocation agent may need to request approval for use of less than 3 comparables and or the use of last resort housing. There must be documentation to support the market conditions. A blanket statement by a relocation agent that the market is limited or very fast moving is not sufficient. The documentation must be specific and complete for the specific real estate market. So let's talk about the search area. The search area may vary depending on the displacement site, its location, and the local market conditions. The search should start in the neighborhood of the displacement site and then expand to include housing in nearby or similar neighborhoods where housing costs are generally the same or higher. You don't want to go into neighborhoods where the houses are not comparable. The area of the search may extend outward from the project area as warranted and is adequately documented. So your search, you're going to show you started in the neighborhood, and then you're going to, maybe expand it out 10 miles, expand it out 20 miles, expand it out 30 miles, and show that you did this in increments, trying to find the comparable housing as close to you could to the location of the displacement. Now, before using last resort housing or less than 3 comps, consideration should be given to expanding the search area, or in some cases, even waiting for the market conditions to change if the project schedule allows. Example of that would be the rental market may improve in a college town during the summer breaks. This could come into play if you're looking for rentals. There's certain times that there's going to be a lot of rentals. There's certain times in a college town there will not be rentals. So the uniqueness of the displacement site. If the displacement site has features or characteristics that are unique to the market, last resort housing or the use of less than 3 comparables may be justified. Examples would be a finished basement or a converted garage, which adds an unusual amount of habitable living space or square footage. A ranch home in an area where ranch homes on the market are rare. Or if you have a house that has an unusually large number of bedrooms. Now, we discussed functional equivalency in the last module, and that a comparable dwelling, it need not possess every feature of the displaced dwelling, but the principal features must be present. Functional equivalency should be considered when you are searching for comparables. So only in unusual circumstances and with adequate justification, documentation, may a comparable dwelling contain fewer rooms or less living space than the displacement site. So let's talk about the timing. So a fast approaching right-of-way clear date may affect the length of a reasonable search. A search should continue until 3 comparable homes within the normal parameters are located. Exceptions would justify the use of last resort housing or use of less than 3 comparables. In all cases of last resort housing or the use of less than 3 comparables, all the decision points must be fully documented. So there may also be justification for use of less than 3 comparables if there is one very good comparable to a unique home and there is a risk of losing that comparable during the search for 2 additional comps. A good example of this would be, the house that ODOT is acquiring. It's a 5-bedroom. It has 3,000 square foot, huge 2-car attached garage. Those are not going to be, easy to find in the market. You go out and you find the perfect comp. And if you keep looking, you could look for 4 or 5 months, and you're probably not going to find a second or a third, but you'll probably lose the one you have. That would be one reason to ask to use less than 3 comps. Again, you've got to do some documentation. You've got to show you searched, and you've got to show the market is not going to produce another one. So what are some good sources to locate your comps? So all reasonable housing market resources need to be searched, and there is no best place to find comparables. The sources will vary depending on the market location. You know, whether you're looking in an urban area or you're looking in a rural area. It's also going to depend on the availability of the computerized data systems. Some areas will have great ones, some won't even have any. An active, knowledgeable, and determined researcher will almost always find the adequate comparable properties. So let's look at some more good resources. For sale by owners, you can find a lot of for sale by owners. Just driving the project, looking for the for sale signs. A good working relationship with the local real estate agents is essential in order to access the multiple list services, also known as the MLS. Most MLSs are now computerized. To gain access to this data, the relocation agent must develop a working relationship with a local MLS member who has access to this system. There are also several internet sites such as Realtor.com, which are very effective ways to find comparables. Another source for comparables are websites maintained by local real estate companies. Over in my area in Crawford County, just because I know the area, I know there's one particular realtor that does not share listings, does not put them in the MLS, but they get a lot of listings. If you're only looking at the MLS, you're going to miss a lot of potential comparables. Newspapers, local real estate publications may also be a source for comps, especially rentals. In most areas, you go to the grocery store, you see the real estate magazines. Those are a very good source. But be cautioned, even though you are working with local real estate agents, it is and that is very important to your search. You must not steer the displaced person to use any specific agents. You can't require them to work with the one that's helping you. So documentation of the search. This is just as important as the search itself. And this is something I've mentioned several times, but it's so important, I'm going to mention it again. The documentation provides the necessary justification and the support for any request for last resort housing or the use of less than 3 comparables. Names and numbers of real estate agent contacts, copies of listings, newspaper ads, computer printouts are all good forms of documentation. No request for last resort housing or use of less than 3 comps will be granted without the specific and complete written documentation. So the prime comparable that you choose will be the dwelling that's most nearly representative of and that is equal to or better than the displacement dwelling. Now at ODOT, we use the RE 611 form to document the comparables and the selection of the prime comparable. And you have a copy of this RE 611. It was in your handouts today. The RE 611 is also used to compute the replacement housing payment price differential and the final payment amount. All the factors of the comparability we discussed in this training are listed on the RE 611. So let's take a quick look at this RE 611 and the different sheets that go with it. So this is your worksheet. On this sheet, you're going to compare the subject with the comparables you have chosen for the housing payment. As you will see, if you look on the left side, there are the specific points of comparability. There's 15 that you are looking for when you're searching for a comparable home. Many factors of comparability are objective, but some are subjective. Thus, the relocation agent must exercise sound judgment when selecting a prime comparable. The comparable may not possess every feature of the displacement dwelling, but again, it must always meet the test of equal to or better. And when you're out comping, this is also a good worksheet to use as you're trying to decide what is going to be comparable and what isn't. The comps you're looking at, use this as a worksheet so you can decide which ones you're going to end up using. Now, along with the previously viewed form, the RE 611, there's also an REPH. Well, this will accompany the RE 611 when you submit it for approval of a replacement housing payment. And this will provide photos of both the exterior and the interior rooms. Now, each area needs to be labeled. There should be a photo of each room in that dwelling, as well as the exterior of the dwelling, any outbuildings, and any other features that were taken into consideration. You will provide a separate REPH for each comparable, as well as the subject home being acquired. So the relocation agent who signs the RE 611 must have personally inspected the interior of the displacement site and all of the comparables used in the determination. One of the main reasons, you got to make sure they're DS&S. You need to see the inside and the outside of these homes for yourself. So a memo to file should be included with the RE 611 when the relocation agent requests approval for their prime comp and the RHP determination. This memo should include a detailed description of the displacement site that is based on the relocation agent's personal inspection, and it should include the following: the age and condition of the home, the layout, size of all the rooms, storage space described in detail. Should address such features such as kitchen cabinetry, flooring, countertops, and other amenities should be described. As applicable, the description shall discuss the finished basements, enclosed porches, 3-season rooms. It should also note any unusual features, extraordinary improvements and amenities, and describe the exterior and the yard. So based on the relocation agent's personal inspection, so a similar description should be included in the memo to file for each of the comparables. Interior, exterior pictures are required of the displacement site and each comparable used in the determination. And you would put them on the pictures are on the REPH forms. All the pictures should be labeled by using the parcel number and the address of the dwelling, a brief description of what is being depicted. And one thing you got to make sure is the forms match. If on your RE11 on the sheet that is showing the 15 points of comparability, if you say there's 8 total rooms and 3 bedrooms, then when you do your photos, make sure you're showing the 3 bedrooms and you're showing 8 total rooms. So the principal consideration when selecting the prime comparable is that the prime comparable, again, must be equal to or better than the displacement site. 49 CFR 24.2 states, while a comparable replacement dwelling need not possess every feature of the displacement dwelling, the principal features must be present. The site to comparable analysis which is also going to be in this memo, should always address any difference between the prime comparable and the displacement site. The analysis should also establish the prime comparable meets the test of equal to or better. And also, if there's any discrepancy by what you found when you inspected the acquired site and what is stated in the appraisal, you need to comment on that. You know, if the appraiser said there was 2 bedrooms and you say there's 3, or he said there was 4 and you say there's 3, then you need to note the discrepancy. And it happens. So this written memo, the RE611 and the REPH should all, again, they should all match. And that's you're gonna put all that together when you submit for approval of your RHP. So now you know how to search for comps. You know the test of comparability. You know how to document your selections on the RE611. So how do you compute the Displaces RHP offer? So the maximum price differential, which is also known as the RHP, replacement housing payment, is the maximum amount that the displaced person may receive for the purchase of a replacement dwelling. So it is the mathematical difference between the fair market value of the site, the list price of the prime comparable. The maximum price differential is computed by subtracting the fair market value of the displacement site from the asking price of the comparable. This amount is commonly referred to as the relocation offer. So in this example on this slide, the most comparable property is priced at $315,000. The acquisition cost, or the fair market value of the displacement site, is $300,000. So the maximum price differential is $15,000. So this is what you would offer the displacee as their RHP. For an owner occupant, you would make your offer on ODOT's RE-0 or -O, actually. The O, that's your offer letter. If you go on ODOT's website, O standing for owner. And as you will recall, this letter that you provide will have the information on that prime comparable in that letter. Now, the displaced person is not required to purchase this comparable as the replacement dwelling. In fact, they don't even have to look at it. You know, what they end up purchasing is completely their decision. What you are doing is you are setting the maximum amount that they can receive. What they actually receive will depend on what they buy. So let's look at the RE611 page 2. This is the actual sheet where you put in your numbers and come up with the actual computation, the actual replacement housing payment. The agent completes the top portion of this form, filling in the price of the prime comparable home and filling in the fair market value or a typical home site computation, which we will talk about later. And then the agent calculates the maximum amount of the price differential. You're going to put in the numbers, and it's going to look like what we just looked on the previous slide. The bottom of this form is completed by the relocation reviewer, and you will note that the reviewer must check each category that applies to the housing payment to confirm approval of: one, he's going to approve that you did the math correctly on the price differential payment; two, if you requested and if he approved use of less than 3 comps; and 3, if you requested and if it was approved for this to fall under the provisions of last resort housing. So once you make your offer to the displacee and they find a suitable replacement home, so how do you calculate what their actual payment is? So the replacement housing differential payment is based on need, and it's based on the displaced person of what they actually incur in purchasing the replacement home. So the differential payment is computed by the lesser of. It's either the asking price of the comparable dwelling, your prime comp, or the actual cost of the replacement dwelling purchased by the displaced person minus the acquisition price of the displaced dwelling. So let's go over an example. So in this example, the displaced person purchased a replacement site that costs less than the list of the comparable. Thus, the actual differential payment was less than the relocation offer. If you look at A, the prime comp, the list of the prime comp was $75,000. The acquisition price was $62,000. So your determination for an RHP, the maximum they could have received was $13,000. The house that they actually purchased cost $70,000, less than your prime comp. So you're going to take the amount of what they actually purchased minus the acquisition price, and what they will actually receive as an RHP is $8,000, because that's all they needed. Now, rarely will you find a property owner that's actually going to leave money on the table, but it happens sometimes. But when you are presenting that offer and when they are actively searching, you have to make sure they understand if they're only going to get what they need. So frequently, the displaced person will elect to purchase a replacement property that costs more than the selected comps. This is what you're going to see most of the time. In these cases, the actual price differential is limited to the price of your prime comp minus the acquisition cost. So let's look at this new scenario. You still have on the top, A is what you calculated. Your prime comp was $75,000, the acquisition price $62,000. So you determined that RHP at $13,000. They bought a house for $80,000. So you take the $80,000 minus the $62,000, and the difference was $18,000. They're only getting the maximum of what you calculated. They chose to buy a more expensive home. You, through your search, you showed that they could have bought one that was $75,000. They chose to buy one at $80,000. So what they will actually receive is only $13,000. So the form RE 611, it also documents what they actually receive. Once you know what they have purchased, now you're going to go back in. Now you're going to put in the cost of the actual replacement site, and then you're going to put down what the final additive that they actually receive. And that is on the RE 611 page 3. And you have a copy of that in your handout. Okay, we're going to do our first knowledge check. Okay, and the question is, question number 1, the relocation offer letter includes all the items listed below except. the address of all the comparables used in the determination, the maximum amount of the housing payment, a notice of not required to move for at least 90 days. Okay, and the answer is A. A is the one that is not correct because it is saying address of all the comparables. The only comparable that you put in that offer letter is the prime comparable. You're going to provide them with the address, and you're also going to provide them with the cost to purchase. The notice not to move for 90 days, that's the 90-day notice that is in every offer letter. Okay, question number 2. The search area for comparable homes is limited to a 20-mile radius to ensure the proximity for work and for schools. Okay, the correct answer is B, because while you will take into consideration where they work and the school system, that is not a that is not a requirement for your prime comp. Question number 3. The prime comparable home must be A, the home that is in closest proximity to the subject, B, located within the current school district, C, a home equal to or better than the subject, or D, a home that offers one floor living, such as a ranch. Excellent. Y'all got it right. Um, Equal to or better. Good thing. I think I probably said that 6 times already in the so far. But yes, it has to be equal to or better. It does not have to be in the closest proximity. It does not have to be in the current school district. And it does not have to have one floor living. Depending on the needs, you may look for those, but they're not requirements. One floor living, you have an elderly person, someone who's handicapped, that may be preferable, but it's unless they have a ranch, it's not required. Okay, any questions about comparability and calculating the housing payment before we move on? Okay, so hopefully this is one area, a carve out where I hope I do not get you too confused. This is something that you know people will have a difficult time trying to understanding and put together. But I think these really are very simple. You just need to not overthink when you do this calculation. So yeah, we're going to talk about carve outs of major exterior attributes. And of course, ODOT has a form for this. It is the RE 612. So the agency's perfect comparable would include everything that a displacement dwelling has. But it doesn't always happen that way in the real world. while the agency will strive to offer a replacement dwelling that is functionally equivalent for housing purposes, there may be certain items outside the dwelling that cannot be found in replacement properties. So, what happens if your displacement site contains a swimming pool or an oversized outbuilding, um, some other type of non-residential features, a lot size that's greater than you would typically find in a residential market? So these features are typically called major exterior attributes. So fortunately, federal regulations outlines a method to handle the situation where the selected comparable does not replace the major exterior attributes that the subject dwelling possesses. So how are you going to make this decision that you've got some major exterior attributes? You know, you once you know what your subject, what do they have? Do they have a pole barn? Do they have a pool? Do they have something else? You're going to look at the market first, and you're going to decide, okay, am I going to find a lot of houses out there that maybe do sit on 5 acres or that do have a, 20 by 30 pole barn? If you're in Florida, maybe, an in-ground pool is not a problem. But, if you're in Ohio and up in a rural area, probably not going to find it. So you must carve out the value of these improvements from your fair market value to develop what we call a typical home site computation, THSC, for your displacement site. You then use this THSC as your acquisition price when computing your RHP offer. You're going to use that instead of the acquisition price. Through this process, you have an apples to apples comparison of your site and the comparables available on the open market that do not possess the same major exterior attributes. And this is a tool that will help you as a relocation agent in trying to find comparable housing. And it does not take away anything from the property owner. Usually, if anything, it gives them a little more money. um, but it's going to help you in your search for comparable housing. So now you're going to look for what's typical for the area. The pole barn wasn't typical, you're taking the value out. So this slide shows a very simple example of a carve-out computation. So let's say your displacement site has an in-ground swimming pool and the fair market value is $300,000 for the entire site. You must review the appraisal report to determine the value of the swimming pool. And hopefully early on, when you did the pre-ac interview and you saw there was a swimming pool, the appraiser was scoped to make sure he has a value on the pool, or he has a value on the pole barn, or whatever it is you're going to need to pull out of here. So your research finds that the appraiser put a contributory value on of 20,000 on that swimming pool. Thus, you would use the typical home site computation of amount of 280 as your acquisition price of the subject site when you're computing your RHP offer. So instead of taking the 300,000 as your fair market value comparing to your comp, you're now only going to use 280 because you pulled out the value of that swimming pool. So here's another situation where you might need to use a typical home site computation. So partial acquisitions sometimes result in small parcels of land being left that we commonly refer to as remainder parcels. If the agency determines that the remainder parcel has little or no value or utility to the owner, it is identified as an uneconomic remnant. So when this happens, the agency must offer to acquire the uneconomic remnant from the owner, along with the property needed for the project. However, the owner is not required to sell ODOT the excess property. So in these instances, you as the agent should discuss this with your displacee prior to making your RHP offer computations to understand if they intend to sell the uneconomic remnant or not. And sometimes, at that early stage, they're not going to be able to give you an answer. They want to see the acquisition monies first. However, if they know and they tell you up front they're going to be selling that uneconomic remnant, they're not going to keep it. Then when you prepare your RHP offer, you can include the amount of the total acquisition, the amount of the money for the total acquisition, and you're going to include the additional the amount of the money that's going to be put on that uneconomic remnant. If the displacee later decides not to sell the remnant, then your computation would be finalized on their acquisition payment without including the value of the excess land. Now, in these situations, what I usually do is I usually just calculate it both ways so they clearly can see. If they sell it, their RHP is going to be this amount. If they keep it, it's going to be this amount. Because I think that helps them to make that decision. But the displacee, they need to be fully aware that they have the option of keeping the remnant or selling the remnant, and they need to understand how that will affect their replacement housing payment. So let's take a look at the RE 616. Okay, and it's actually I think it's a pretty simple form. And when as you'll see, there's a column on the right. You're going to put on everything that the appraiser has separated out. On the column on the left, you're just moving over the values of what's in your typical home site. So in this situation, what you would not move over from the example we gave, you're not moving over that value of the swimming pool. You're moving everything else over, but you're not doing the value of the swimming pool. If you were doing the one with the excess land, then you're going to do one where you're moving everything over, including the excess land value. Or if they're not doing if they're going to keep it, then you're moving everything over except the value of the excess land. Okay, let's talk about the increased interest payment. So the increased interest payment, also known as the mortgage interest differential payment, in federal highway terminology, is designed to compensate the displaced owner occupant for the loss of a favorable interest rate on their displacement site. So let's say the displaced site, they've got a interest rate on their mortgage of 5%. Now, because they're moving and they have to get a new mortgage, now they're going to have an interest rate of 6%. So the agency can only consider mortgages that were valid liens on the property at least 90 days prior to the initiation of negotiations. And the displaced owner occupant has to incur a higher interest rate on the replacement mortgage to be eligible for this payment. Federal regulations still reflect a 180-day requirement for the increased interest payments if you check 49 CFR. However, in Ohio, we have a law that says our regulation is 90 days, and because it's a law, Federal Highway recognizes that. So how does it work? An increased interest payments are commonly known as buy down payments and are made to compensate the displaced person for the loss of favorable financing at the displacement site due to the agency's acquisition. So the definition from our Policies and Procedures Manual and from CFR says the payment for increased mortgage interest costs is the amount which will reduce the mortgage balance on a new mortgage to an amount which could be amortized to the same monthly payment for principal and interest and for the same duration as the mortgage on the acquired site. So in other words, to kind of make it a little more simple, the increased interest payment will result in an amount that is needed to reduce the new mortgage on the replacement site to an amount that results in the same monthly payment at the displacement site property. If they took the lump sum of the increased interest payment, took it to the bank, paid it down on their mortgage, in the end, it brings their payment down and the balance down based on that interest rate of what they have. So since the interest rate is higher, the displacee would only be able to finance a lesser principal amount than their current mortgage balance to yield the same payment and loan duration. Now, the difference between their current loan balance and the lower principal balance is what we would pay them. They could then use this amount to buy down their principal at the replacement site to maintain the same monthly principal and interest payment and the mortgage term. Now, this is something that when we get into advanced residential, we will go into in much more detail. For now, this is just kind of a quick overview of how this works, so you understand there is a buyout process, there is an increased interest payment, and this is based on when current mortgage has a lower interest rate than the new mortgage. Now at ODOT, we have an Excel spreadsheet program, which is available on ODOT's website, that does both an estimate for increased interest, which you do an estimate up front and you give it to them when you make the offer, so they understand if they even need an increased interest payment or if they may be eligible for one. And then there is another one that calculates the actual payment once they purchase the replacement site and actually have the numbers, the new interest rate for the new mortgage. So even though the program calculates the payment for you, it's essential that you, the relocation agent, be able to explain the concept behind the payment to your displacees. And again, this topic is covered in much more detail in the advanced residential relocation classes. I think at this point, just know that there is a payment out there, and the purpose of this payment is so on the new mortgage they're going to have the same payment and of the principal and interest, as long as they take it and they apply it to their new mortgage. So incidental expenses. These are also called the settlement costs or the closing costs. So displacees are eligible for reimbursement of those costs customarily paid by the buyer. So you as the agent must determine if the costs are reasonable and necessary for the transaction. An expense is the amount typically charged and that is required for the transaction. So a displacee who did not have a mortgage at the displacement site is not eligible for reimbursement of mortgage-related closing costs. They should not, if they take our acquisition monies and our RHP monies and buy a displacement house, within the means that we're providing them. They should not need to go out and take out a new mortgage if they don't have one. Therefore, we don't participate in any fees for a new mortgage. So all incidental expenses must be measured by our standard test of actual, reasonable, and necessary. And you as the agent must know what is customarily paid and reasonable amounts for the items and the services. So being new to relocation, you're probably going to rely on your reviewer and the district real estate administrators to determine what is actual, reasonable, and necessary. And do not hesitate to contact the closing company and demand clear explanations of what they are charging. You know, from one closing statement to another, you're going to see different fees. You're going to see different names for, you know, for the same fee. You know, when I would look at a closing statement, I almost always had to call the title company to say, okay, I need you to explain to me what are these 5 charges here, and because they would have names that I had not seen before. But once they would explain what the charge is, just like, oh, okay, I know what that is. Or sometimes they throw different, new fees on there, and at that point you have to decide, is that a reasonable fee? I mean, they can be pretty tricky on what they are charging. And we've seen examples where they have, they've really padded their costs on these closing and settlement statements. Now, you will obtain most incidental closing costs on one of the following forms: either a HUD-1 settlement statement, there's a Consumer Finance Protection Bureau's closing disclosure statement, which they give ahead of time. There's also American Land Title Association settlement statement. So the Display C provides this to you, and always ask to see this prior to the closing, so you can go over the form, go over all the fees on there, and make sure that they're going to be reasonable before the Display C actually goes to the closing. And again, closing and settlement statements, this is something we go into in much more detail in the advanced residential class. So some of these expenses are completely reimbursable, and others are only partially reimbursable. Items such as appraisal fees, survey fees, application fees, credit reports, escrow agent charges are usually fully reimbursed if the agency determines they are reasonable and necessary. Some incidental expenses may only be partially reimbursable. For example, if the displaced person purchased a replacement dwelling that exceeds the cost of the agency's selected comparable, let's say the prime comparable was $100,000, and they go out and they buy something that is $200,000, then they will incur additional costs in the purchase of that more expensive home. These expenses are not considered necessary and therefore not reasonable. One of the potentially partially reimbursable costs would relate to title insurance. Title insurance protects against the financial loss resulting from claims arising out of the defects in the title of the real property. These are defects that existed but were undisclosed when the title company issued the policy. So here's an example. Your displacee may purchase a replacement dwelling, $250,000, and obtain an owner's title insurance policy for this amount. But your prime comp was priced at $225,000. The reimbursement for the owner's policy would be limited to the cost of a $225,000 policy. The title insurance is based on the cost of the home. So in this case, you prorate you're going to prorate what the cost would be if it were based on a $225,000 home, which was the prime comp, not the more expensive home that they chose to buy. Other costs that are tied to the sales price, such as documentary stamps, sales tax, and other transfer taxes, would also be limited by the cost of the prime comparable selected by the agency. So in addition, any costs associated with obtaining a mortgage for the replacement dwelling would be limited to the principal balance of the mortgage currently owned for the displacement dwelling. For example, if a lender is charging a 1% origination fee for the new mortgage of $200,000 and the displacee only had a principal balance on their old mortgage of $100,000, then the reimbursement will be limited to 1% of $100,000. Again, they're choosing to buy the more expensive home, or they're choosing to take out a more expensive mortgage. So non-reimbursable costs are typically categorized as escrowed prepays and include interest from the date of closing through the end of the month, homeowners or hazard insurance, we do not reimburse for those. County property taxes or assessments, we're not paying for those. Private mortgage insurance, which is typically required on purchases with less than 20% down, unless a lump sum payment is required for financing. Some government mortgage, such as VAs, may require this. And as I said before, if a displacee didn't have a mortgage at the displacement site, they would not be entitled to any reimbursement for any cost associated with the new mortgage. Okay, we are ready for our knowledge check, our number 2. First question, if the prime comparable is $100,000 and the acquisition price is $80,000, what would the calculated maximum RHP be? Would it be $8,000, $15,000, or $20,000? I think that one was too easy for you guys because you guys all got it. Question number 2. An administrative settlement has no effect on the maximum differential payment. And the correct answer is B. If there's an administrative settlement, that changes the acquisition amount and you have to recalculate. So if your fair market value originally was $75,000 and now it's $80,000, now you have to recalculate using the $80,000. So it will absolutely change your replacement housing payment. Question number 3. The amount of the replacement housing payment will always be the same amount of the RHP stated in the offer letter. And the answer is B, false. The amount of the price differential payment actually received is based on the cost of the replacement home and what the displaced person actually spends. So you, in the offer, you are setting the maximum. The maximum is what is in the offer letter. What they actually receive is going to depend on what they buy. Remember, you first calculate based on your prime comparable. You second adjust it to what they actually purchase. Okay, now we're going to talk about the rental assistance payment. So 90-day owner occupants may decide they no longer want to own a dwelling. In this case, the owner can elect to become a tenant and eligible for a rental assistance payment. This is something we did touch on in Module 3. So to calculate their payment, you as the agent must first determine the economic rent or market rent of the displacement site, along with their average monthly utilities. Economic rent and market rent are one and the same, just different names. So just know that it is the same thing. So the utilities may include gas, electric, water, sewer, and other heating and cooking fuels. And I will cover the calculations and how you determine economic and market rent in great detail in the advanced residential course. So the economic rent and utilities are then subtracted from the monthly rent and utilities of a comparable replacement dwelling. So of the site we're acquiring, since our appraisal has a value to purchase it, you have to decide, but what if it were being rented, and you have to establish a rental amount for it. That's what you're doing with an economic rent or a market rent. You have to do that because you have to have something compare to a rent to get a rent supplement payment. And yes, you will need to recomp your parcel to rentals if your displacee decides they no longer want to own. So you're doing two housing payments because you first have to do the RHP. Then they're going to say, yeah, but I want to be a tenant. Now you have to develop your economic rent, market rent, and now you have to recomp them to a rental. So this monthly differential between the displaced sites, rent, and utilities, the difference between that and your comp is multiplied over 42 months to arrive at their rental assistance payment, which cannot exceed their RHP offer. We will talk about this a little more in the next module, but the owner's income is not a factor when computing a rental assistance payment for a 90-day owner. Income comes into play if you have a tenant occupant. It doesn't come into play if you have an owner occupant who changes their status. Okay, now we're through the module, and I'm just going to go over the learning outcomes for you, kind of just to refresh your memory and remind you of everything we just went over in this. And I see I'm about 9 minutes over, so I'm going to try to run through this very quickly so I don't keep you over. And once I get done with this, just remember to follow up and take your quiz. So let's review our objectives for this module. First of all, what constitutes a regional search for comparables? Your search must be efficient and exhaustive. Your search must be well documented. Your local real estate market will affect your search. If it is a fast-moving market, houses get sold quickly, you may need to seek approval for less than 3 comps. The search area affects your market. You may have to expand your search area if you cannot find suitable comps. Uniqueness of the displacement site may affect your search, and remember that what we are striving for is functional equivalency with our comps, not an exact duplicate. You're not going to find an exact duplicate. Timing may affect your search. If you have a fast approaching right-of-way clear date deadline, you may have limited comps to choose from. We also talked about the good sources to find the comps, how you need to get access to the local MLS system to have the best chance of matching your site. So how do you compute the replacement housing price differential offers? You conduct your search, locate your 3 comparables. You must personally inspect the interior and the exterior of each comp and take photos. You then compare these dwellings to your site. You measure their comparability against the 15 factors. You choose your comp that is most nearly representative of and equal to or better than your site. This is your prime comp, and it is the one you base your offer on. Then you subtract the fair market value from the price of the prime comp, and that is the Displacee's RHP offer amount. That is what goes in your offer letter. All your work is documented on the RE611. In addition, you have to create your memo to file, which details the site and the comps and your analysis and your search. And then you make your offer to the owner occupant on ODOT's REO, which is the offer letter. So how do you determine your final RHP payment? Once your displacee selects the replacement property, you calculate the final RHP payment. The payment is based on the lesser of the asking price of the prime comp or the actual price paid for the replacement property. Remember, if what they buy costs less than your prime comp, they may not receive the full amount of the RHP. They have to spend it to get it. A carve-out is performed when your site has a major exterior attribute that cannot be found in the typical residential market. What could some of these be? A swimming pool, a pole barn, extra acreage. You are carving out those values out of your acquisition so you can compare apples to apples. So how do you deal with the uneconomic remnant when you're calculating the final RHP? You have to make sure the property owner understands their RHP is going to depend on, do they sell the remnant or do they keep the remnant? If they sell it, then you can use the acquisition for the whole property. If they keep the remnant, then you have to carve out the value of that remnant. So we talked about the increased interest payments and how the buy down process works. We talked about the incidental closing costs and how some are fully reimbursable, some are partially reimbursable, and some are just not eligible for reimbursement. We talked about the cost for mortgages, the any fees relating to a mortgage on that closing statement. If they don't have a mortgage in the before situation, they are not eligible for reimbursement of any fees relating to a new mortgage that they chose to take out when they did not have one in the before situation. Okay, so that is my refresher, my follow-up at the end of Module 4. And are there any questions before we end this module and let you move on to taking your quiz? Okay, I do not see any questions. If you have any questions that come up later, feel free to send me an email, give me a call. More than happy to discuss any of the subjects with you. Some of these we're only keep in mind overview. So if you think you're lost and you don't quite understand something, a lot of these will be in detail when you take the advanced residential class. However, if you really want some more information on anything, feel free to give me a call. And with that, that concludes Module 4.